My name is Andrew Nyamayaro, a solicitor at Tanlo Solicitors. Today, I'm going to talk about ways in which you can challenge a Home Office decision. So the topic that I have today is, what do I do if I receive a Home Office decision? So when you receive a Home Office decision, sometimes it's a time of joy because you have received a positive decision. Whatever you've applied for from the Home Office might have been granted, in part or in full, and maybe meeting the conditions that you have applied for. Sometimes they might alter the conditions, and again giving you a reason to try to challenge. But at the same time, when you receive a Home Office decision, it might not be a positive decision. You might receive a rejection, or you might receive a refusal. So what is a rejection? A rejection is done by the Home Office whereby they do not accept your application, but they've not considered the merits of your application. They've rejected it based purely on technicalities, such that maybe you didn't submit a certain document, or sometimes that you didn't pay a certain amount of money, and so forth. So it might be a rejection in cases of, say, people that are on the skilled worker. If you do not pay the, say, ISC or something like that, then you might receive a rejection. The good thing about the rejection is that you can apply straight away to resubmit your application. So Home Office decisions also come in various ways. It could be a Home Office decision for an individual, or it can be a Home Office decision for a company. If a company is applying, for example, a sponsor license, they might also receive a positive acceptance of their application. They might receive a refusal, or they might also receive a rejection. Either way that happens to businesses as well. To individuals, it can also be rejected, refused, or accepted by the Home Office. But now I'm going to look at circumstances where the Home Office have sent you a decision and you want to consider your options. So what do I do if it's not a positive decision? If it is not a positive decision, you've got several options that you can do. So once you receive a Home Office decision, the first thing is you review the decision itself. What is the decision saying, even if it's a refusal or a rejection? Why has it been rejected or refused? Look at the reasons, and if it has been refused, then you have to consider whether or not there is any prospects of success in trying to challenge the decision that is coming from the Home Office, in whichever way you're going to challenge it. Most of the ways that you have to challenge the Home Office decision, a fee is applicable, and you might have to pay experts or lawyers to then support your case. So is it worth pursuing or not? So if a decision is refused, the Home Office might give you what is called a right of appeal. A right of appeal is granted mainly in human rights applications, and it's also granted in protection cases and humanitarian cases. If you are given a right of appeal, you have got 28 days to appeal if you're outside the country, and you have got 14 days to appeal if you are within the UK. And there is a fee that is applicable to the court, which is currently £140. If you are on legal aid, you are not supposed to pay the fee, or you not be asked to pay the fee. But if you are a private paying client or a person, then you might have to pay the fee for the court. And the fee is per individual. So if you have 5 members of the same family applying, then you will have 140 times 5. So sometimes you can qualify for a fee waiver from the court, if, for example, you're on a legal aid basis and so forth. And also you must be careful on how to do it, because the applications, mostly they are now done online. Unless if you're a person that is in detention or that is in prison, that's where maybe you might have to do an application on paper. So one of the ways of challenging a Home Office application refusal is by way of an appeal, in which you are stating that the Home Office is failed to consider the merits, the prospects, the evidence, the way that was supposed to be, and so forth, and then you appeal the case. Our experience at the moment is that most appeals are taking more than 12 months to be decided. And there is also talks by the Home Office or the government to improve the Immigration and Asylum Tribunal Services procedures. They want to make a decision within 26 weeks. Whether this is going to be plausible or not, we are yet to see. The next way of challenging a decision is by way of administrative review. And administrative review is applicable mostly when you are dealing with points-based applications. These are applications for refusal of student visa or skilled worker visas, things like that. Those are ones that are challenged by administrative review. So in administrative review, you are saying that the caseworker has made a clerical error, has made a caseworking error, and that's so much that their decision is affected. And mostly it's just considered on the evidence that you have submitted, although when you are applying for an administrative review, there's also a chance for you to submit any additional documents or upload documents when you are doing an administrative review. Off my head, the administrative review fee is £80 that you pay to the Home Office to do the administrative review. And again, it has got time limits. If you're outside the country, 28 days. If you're within the UK, 14 days. So you have to clearly make your points known, your challenges known, because with an administrative review, the decision is made on paper only. It's paper-based. They will not call you or talk to you. They'll just consider the reasons that you have said. So you have to submit very strong grounds why you think that there is caseworking or clerical error that has been done by the Home Office. For example, you submitted all the evidence and they didn't consider the evidence that was submitted, and it's clear that the caseworker didn't do their job properly, then you can challenge that under administrative review. For those that are joining me now, I am talking about ways in which you can challenge the Home Office if your decision is refused or your application is refused. If it is rejected because the Home Office has not looked into the merits or otherwise of your case, you can just make a new fresh application again. And in most cases, if it's rejected, you will get your fee back that you have paid to the Home Office. So far I've commented on administrative review, and I've also commented on appeal. All these things that I'm talking about, we do help you at Tanlo Solicitors. Whether you want to make an application for a visa, an application for administrative review, an appeal in the court, Tanlo Solicitors can help you. With other areas of law that we do, which include employment, immigration, wills, probate, business, and corporate. We also do dispute resolution. The other way in which you can challenge the Home Office when they've refused your decision is called judicial review. So with judicial review, it is a process whereby you are challenging a public body that their decision is maybe not unreasonable, rather their decision is unreasonable or is unfair or doesn't meet public interest requirements and so forth. So you challenge it on judicial review. So with the judicial review, it has got different grounds, and it also has different stages that are applicable. The first stage in the judicial review is to do what is called the pre-action protocol. This is a letter or a legal form that you complete and send to the Home Office. You have to put all full information, because if you do not put your proper grounds and full grounds in the pre-action protocol, you might have problems justifying your application in the court, and then the upper tribunal or in the High Court when you go for application for permission for judicial review in the courts. So you have to put a full factual background. You have to put the legal arguments, case law that you are relying on, guidances that you are relying on, policies or procedures, and you have to attach these ones or quote them and directing the caseworker to the correct position where they can see the sources or cases or authorities that you are relying on. You send this letter to the Home Office, to their litigation department, but which considers the pre-action protocols. There is a specific email that you have to send them to. Otherwise, you have to send them to their office in London, which is where they do these litigation / pre-action protocol cases considerations. Also remember that when you're sending emails to the Home Office emails have got a capacity limit, mostly of 20 MB. So if you're going to send any documents that are over 20 MB, make sure that you send it in a series of emails, or try to compress your documents using software that is available to compress PDF information. So when your Home Office application is refused by the Home Office and administrative review is not applicable, there's no right of appeal, you do the judicial review. You have got up to 3 months less 1 day to submit your judicial review application to the court. And you can do your pre-action protocol anytime within the 3 months. But try to time it so much that you give the Home Office enough time to respond. In the pre-action protocol, we normally give them between 14 and 21 days to respond, mostly 14 days. And in most cases, the Home Office will respond in the 14 days. They might agree with your arguments, or they might disagree with your arguments. They might agree partially with your arguments, so it just depends on what they say. And again, at that stage, you need to review your case. Is it still worthwhile going for the court case in an application for judicial review, or it's no longer necessary to go forward? The challenges of going forward if the pre-action or protocol is refused is that when you go to court, number one, you might need a lawyer. And then if it goes to oral hearing, that lawyer might also then need a barrister to attend, because lawyers do not have the right of audience if it's going to the High Court. And even in the upper tribunal, if it's in judicial review, it will be the barrister that they need to instruct. You have also to bear in mind that if you lose your case, the Home Office will make a costs order, rather the court will make a costs order against you, which will be enforced with the Home Office. And if the Home Office enforces the costs order against you, and it's in their books that you have not paid the costs order or any other money that you were supposed to pay to the Home Office, for example, if you were supposed to pay for services of the NHS, if you don't qualify for NHS free services, then that will be counted against you by the Home Office when they're making decisions, even by the court under the good character and suitability. So you have to consider all those factors. And again, depending to which stage the Home Office takes your case or the court entertains your case, the costs might go up as well. Then that will also depend on the grade of the lawyer and the barrister that you have used. Senior lawyers will be more expensive than paralegals, for example. Silk will be more expensive than a junior barrister and so forth. So you have to be very careful. So judicial review is when you are challenging a public body to say that their actions are contrary to public policy, public interest, irrational, unfair, and so forth. So those are the reasons that you will be looking at. Again, I want to emphasize it is important to consider the deadlines. If you miss the deadlines, particularly the administrative review and the appeal, that will also then tend to affect your automatic right that we have under Section 3C. Section 3C, Section 3D are under the Immigration Act, whereby there is an automatic extension of your visa when you are still challenging the Home Office. If you delay, then it will lapse. People confuse Section 3C and the right to work. Sometimes you might find that the Home Office might not be able to find your right to work, and the employer have to do an employer check rather than the usual right to work, which is normally done so that they can confirm that you have got something that is ongoing with the court or the Home Office, and you can still continue to be able to work. I've also commented on the issue of costs. All three ways except judicial review or pre-action protocol stage involve costs. If you are going to go to court for judicial review, there's a court fee. Again, for each individual, it's £160 for the application, the initial stage. If you want to challenge up to the second stage, I think it will be £160 to go for the oral stage hearing, if that becomes necessary. But some people might qualify for fee remittances, especially with the judicial review. So you have to check if you can qualify for a fee remittance from the court and make an application to that. So this is what I had for you today, talking about what do I do if I receive a Home Office decision. If you receive a positive decision, that was what we were looking for, that is what you applied for, then congratulations to you. Sometimes the Home Office might give a decision that is midway or that is not exactly what you applied for. For example, you might have applied for indefinite leave to remain, or you might have applied for refugee, and they end up giving you a human rights-based decision and so forth because of the other factors that are applicable. And they might say no, and if they say no, what do you do? If they say no, then you can consider administrative review, lodging an appeal, or submitting a judicial review, depending on the nature of the decision, and the application that you have made. Points-based applications normally go under the administrative review. Human rights applications and protection and humanitarian, normally you get that for appeal. Judicial review can apply where you have not been given the right of appeal, you have not been given an administrative review if such a case could have warranted to have it, or certain applications like a visitor's visa does not qualify for administrative review, neither does it have an appeal right. So for visitor's visa, if you are going to challenge it, you need to consider judicial review. If you've got any questions that you have, if you've got any help that you need, if you want any assistance, do not hesitate to contact Tanlo Solicitors. We have got a number of lawyers that will be able to help you with your cases. Simple questions we might answer, but remember that we are here to help people on a full-scale basis. That's why we charge consultation fees, and we also charge fees for our services. Until next time again, thank you so much. My name is Andrew Nyamayaro.